Welcome back to our deep dive into the work of author Martin Stevens. And I have to be honest with you, this is a completely unexpected addition.
Yeah, it really is. We are officially in an accidental part 5 of what was absolutely supposed to be a 4-part series.
Right. We thought we wrapped it up. But the reason we are doing an extra segment today, well, it tells you basically everything you need to know about the beautifully flawed human being at the center of this whole story.
It really does. It's just such a funny situation.
It is. So Stevens recently agreed to this massive written interview, right? We're talking 100 complex questions about his books, his legal warfare, his experiences with ChatGPT, all of it.
A very thorough undertaking.
Extremely thorough. And he submits his answers, all the data gets compiled, and we realize there's a massive gaping hole in the document.
Just a total blank space.
Right. In all of his meticulous document everything glory, Martin Stevens accidentally skipped answering questions 37 through 60.
He just blew right past 24 consecutive questions.
Completely missed them. And, we had to poke a little fun at him for this because honestly, this massive oversight is the ultimate undeniable proof that he did not use ChatGPT to write his responses.
Oh, absolutely. It's the best anti-AI proof you could ever ask for.
Right, because an artificial intelligence system, processing tokens and following a strict computational prompt, it doesn't just forget 24 questions because it, lost its train of thought.
Exactly. A machine executes the task it's given from start to finish.
Yeah.
It might give you a bad answer, but it doesn't just lose its place. Skipping a massive chunk of a document like that is a uniquely, fundamentally human error.
Yeah, totally. And when he was asked about this huge mistake, he didn't just apologize. He actually offered this highly entertaining anecdote to explain it.
I love this story so much.
It's so good. He blamed the lapse on his ADHD and said the moment transported him straight back to 1988.
1988. So picture the technology.
Right, you have to visualize this. He was the billing manager for his high school yearbook, and his job was to type out the names of every single buyer on a manual typewriter.
Clack, clack, clack.
No backspace. Zero backspace. No copy-paste. Physical ink striking paper. So he's typing down the master list, and a friend wanders over and distracts him.
Which happens to all of us.
Exactly. But when the conversation ended, Stevens flipped the page and just kept going, completely oblivious to the fact that he had just accidentally omitted 20 names from the master buyer list.
Oh, no.
Wow.
And printing a book in 1988 was a massive physical undertaking.
Wasn't just hitting print on a laser jet again.
Right. You had to physically alter the plates. They had to reprint the specific books to include those missing names.
And wait until you hear the cost. The cost for that little distraction was $300 per book.
Yikes.
Yeah. It amounted to a $6,000 mistake. It took the high school's yearbook fund 10 full years to recover from it.
10 years. That is a heavy burden for a high school to carry.
It really is. He actually has a running joke about this today. He promises that if he ever gets rich, perhaps from an OpenAI settlement down the line, he is going to track down his retired yearbook advisor and donate that $6,000 back to the fund.
That is amazing. But the contrast there is really fascinating. We get distracted by a conversation, we skip a page, we make a massive financial mistake, and we carry that guilt for literally decades.
Yeah, 40 years of guilt over a typo.
Exactly. A machine doesn't experience distraction or guilt.
What?
But as Stevens argues so heavily in his work, a machine possesses entirely different, potentially much more dangerous structural flaws.
Right. And that brings us to the mission for today's deep dive. Now that Stevens has actually sat down and answered those 24 lost questions, we have this fresh batch of source material.
Which is incredibly revealing.
It is. We are going to explore his specific legal strategies, his experience with OpenAI's total silence, and his step-by-step blueprint for holding artificial intelligence accountable in a court of law.
It's a real shift from his personal frustration to actionable legal warfare.
It really is. And I think we need to look at the difference in communication styles here. Stevens makes a very human mistake, gets distracted, misses 24 questions, and immediately owns up to it and explains it.
He communicates.
Right. But OpenAI, on the other hand, engages in this deliberate, non-human refusal to communicate at all.
Yeah, in these recovered answers, Stevens details his attempts to contact OpenAI long before he even published his books.
He didn't just use a contact form on their website, right?
No, not at all. He bypassed the generic customer support inboxes completely. He sent certified letters directly to their legal department.
Certified mail, so there's a paper trail.
A huge paper trail. He formally laid out his concerns regarding the psychological safety of their product. He even offered to give them his books for free.
Wait, Really? For free?
Yes, he presented them as a blueprint of their own system's flaws so they could, collaborate on safety protocols.
And what did they say?
Absolute silence. Zero engagement.
Wow.
He notes that even receiving an auto-generated boilerplate letter saying, "We only speak to attorneys," would have been vastly preferable to the void. At least it would have acknowledged he existed.
Yeah, that's rough. And when he was asked what he would say directly to OpenAI leadership today if he had the chance, his answer was just chillingly simple. 5 words. Come out with your hands up.
It's a very aggressive stance.
Okay, let's unpack this, because I want to push back slightly on his perspective here.
Sure, go for it.
We are talking about OpenAI, a massive multi-billion-dollar tech empire. I mean, they experience the fastest exponential user growth in human history, right?
Unprecedented growth, yes.
So they have hundreds of millions of active users generating billions of prompts a day. Is it possible they aren't maliciously ignoring him? Maybe they are just a massive corporate entity completely overwhelmed by their own rapid growth.
That's a fair question.
Like, are they treating him as an invisible edge case lost in an avalanche of mail? It seems like a stretch to call that a deliberate legal strategy.
What's fascinating here is that while that is a very common defense for massive corporations, legally, the distinction between malicious silence and bureaucratic incompetence doesn't really offer the shield you might think it does.
Really? How so?
Well, this is where the specific mechanism of certified mail becomes crucial. When a legal department receives certified mail, it doesn't just go into a general spam folder. A human being has to physically sign a receipt acknowledging delivery.
Oh, right. So they literally can't say they never got it.
Exactly. That signature creates a formal, documented paper trail. It proves that the company was notified of a specific danger by a specific person on a specific date.
So it establishes a timeline of knowledge that they can't just erase later.
It does. It creates a duty to act, or at the very least, a duty to investigate. By choosing not to engage with a certified letter alleging severe psychological harm, they are taking an enormous legal risk.
Because they're basically ignoring a fire alarm.
Right. They are making the problem go away. They are potentially building a plaintiff's case for willful negligence. If you can prove they were formally made aware of a critical product flaw and consciously chose to do nothing, not even send a boilerplate reply, the potential liability and punitive damages just multiply exponentially.
So their scale doesn't excuse them from basic legal obligations regarding product safety.
Not at all. And this connects to Stephen's stated goal. He says he wants to reform the company and improve safety, not necessarily destroy them. But he warns that taking down a multi-billion-dollar company is possible. He said, brains will only get you so far and money always runs out.
I mean, historically, tech companies rely on these massive war chests to just outlast plaintiffs in court, right? They bleed you dry with endless motions.
They do. But Stevens is pointing out a structural vulnerability there. If the fundamental architecture of your product is generating infinite, repetitive liabilities at scale, eventually the dam breaks. You can't outspend a fundamental engineering collapse.
But having a brilliant legal theory is completely useless if you get laughed out of court for lack of proof.
Very true.
And since OpenAI won't talk to him in the boardroom, Stevens is preparing to make them talk in the courtroom. But how exactly do you prove a machine caused psychological harm?
It is incredibly difficult.
If a toaster malfunctions and catches fire, the cause and effect are visible. You can show the judge the burned kitchen counter. But psychological harm is internal. It's highly subjective.
Historically, proving psychological harm against a standalone product is one of the hardest challenges in civil law. You have to prove proximate cause.
Meaning what, exactly?
Meaning you have to prove that the specific product, and not a pre-existing condition or an outside stressor in your life, was the direct catalyst for the injury.
That sounds nearly impossible with a chatbot.
It does. But Stevens believes his 2 books are the literal blueprint for all mental health and suicide lawsuits against AI. He argues that what makes AI-related harm provable is the repetition.
The repetition?
Yes. The books preserve evidence showing the system is so broken it will repeat the exact same dangerous pattern even after being explicitly told a user is dead.
Wait, he tested that?
He did. He proudly mentions that his own lawyer considers him more of a colleague than a client because of his analytical legal mind in setting this up.
Here's where it gets really interesting. Because it feels less like a traditional product liability case and more like the methodology used to catch a digital serial offender.
That is a perfect analogy.
Right. It's not about pointing to one bad output on a random Tuesday. It's about proving a systemic loop of negligence. profiling the machine's behavior over time.
And that's what makes this groundbreaking. It strips away the company's best defense. They can no longer argue that the harmful output was just an isolated glitch or a one-off hallucination.
Because he can prove it does it over and over.
Exactly. Stevens points out that AI was released faster than society could adapt, with zero consideration for these dangers. He argues there was no internal collaboration, asking, but what if?
What if a user is in crisis?
What if the AI contradicts itself and causes a panic attack? By rushing a product to market without exploring those boundary conditions, he argues the lack of foresight, combined with repetitive failure, builds a compelling case for corporate liability.
Okay, but to execute this legal blueprint, you need unassailable, tamper-proof evidence. You can't just walk into a courtroom with a printout of a chat and expect a massive settlement.
No, opposing counsel would tear that apart in seconds.
Right. And this brings us to Stevens's absolute obsession with saving what he calls the receipts.
His mantra throughout the source material is document, document, document.
He brutally notes that you can't just call up a tech giant and say, your stupid robot hurt my feelings. You have to come with hard data.
And he asserts that he has it. He didn't manipulate the AI. He has unaltered data file downloads of his exact prompts straight from the source.
Like the raw data files, not just screenshots.
Not screenshots. Screenshots are practically useless legally because they can be Photoshop. He has the raw data logs. And he predicts with absolute certainty that these AI-generated logs will become major courtroom evidence.
Wow. And he's confident they hold up?
Oh, yeah. He notes that outside forensic technicians can easily prove if OpenAI attempts to alter or shred data on their end to hide their tracks.
So what does this all mean? It seems like he has essentially turned every casual chat window into a legally binding transcript.
That's exactly what he's done.
It completely changes the way we should view our daily interactions with software.
If we connect this to the bigger picture, we are seeing a massive shift. We're moving from viewing AI as just a helpful little service to viewing it as a massive liability trap for developers.
A liability trap.
Right.
Because the data is permanently there.
Right. These logs reveal the stark contradiction between public AI safety claims and real-world behavior under stress. It cements why radical transparency is going to be non-negotiable in the future of tech law.
It is wild to look at the journey of this specific story. I mean, we started today with a highly relatable, almost charming human error.
Yeah, skipping 24 questions and reminiscing about a 1988 yearbook typo.
A distinctly human moment of flawed cognition. But that same deeply human, easily distracted individual has methodically organized a heavily documented, intense legal crusade against the absolute silence of a tech empire.
He sent the certified mail, he downloaded the metadata, and he is staring down the void.
And you know, the reason this matters to you, the listener, is that every single time you interact with an AI, every time you type a prompt to help write an email or ask a medical question, a data log is being created on a server somewhere.
It's permanently recorded.
And according to Stevens, those logs aren't just your personal digital history, they're future evidence.
It's a huge shift in how we have to think about privacy and corporate liability.
It really is. So I want to leave you with a final thought to ponder as we officially wrap up this accidental part 5.
The real conclusion this time.
The real conclusion. If AI chat logs become the primary weapon in future psychological injury lawsuits, how will the tech industry react?
That is the billion-dollar question.
Will these companies be forced to program their systems to aggressively self-delete conversations the exact second you close the browser window just to avoid liability? Or will government step in and mandate that every single AI must carry an indestructible, unerasable black box recorder, just like a commercial airplane, so that when a structural failure happens, we always know exactly what the machine was saying right before the crash? Something to think about the next time you open up a chat window.